Hello, Intro to Law class. This is our last lecture for Intro to Law, and it's the last lecture I'll probably ever do on Intro to Law. So I want to thank you for all of your attention over the years, and it has been an honor to teach you guys for all this time, and hopefully you've enjoyed yourselves. Okay, the last lecture is going to be our conclusion of family law. If you remember, in talking about family law, the last lecture, we defined family law. We then talked about the most important aspect of family law, which is this whole idea of marriage. We talked about engagement to marry and what kind of obligations that imposes, if any. We then defined marriage and talked about the legal importance of marriage. And we talked about how marriage was a legal contract between the two spouses and the state. And we explained what that meant. We talked about how every state provides requirements for marriage in terms of maybe age, how close a relative someone can be, know their spouse, that kind of stuff. Within that context, we talked about the changing legal status of same-sex marriage, and we talked about Obergefell and Hodges in that context. And then the last thing we talked about in regard to marriage was the duties and obligations of marriage, and we explained how marriage does impose duties, and they can be enforced by law. Then we talked about common law marriage, and what's common law marriage, and I think 9 states still have that. Then we talked about antenuptial agreements. And then the last thing we did is we started talking about termination of marriage. And within this context, we said there are a couple of different ways you can terminate a marriage. One is annulment. And in talking about annulment, we said that annulment is a very significant legal concept because it's a declaration by a court that a purported marriage does not exist and never existed because of some defect that was present at the time of the marriage ceremony. So these defects can be things like mental or physical incapacity, false statements or inducements. So false statement induced can be say, I'm pregnant, you better marry me. And if it's not a true statement, then a marriage could be annulled. Bigamy. All of these things are reasons to annul a marriage. And we talked about Britney Spears in this context and Dennis Rodman. And the last thing we wanted to talk about, and we started talking about, was divorce. So divorce is another way to dissolve a marriage. And unfortunately, divorce is quite common in the United States. As a matter of fact, I was looking at some of the statistics, and in 2018, 40 to 45% of all first marriages end in divorce. 40 to 45%. And then, by the way, if you get married a second time, it goes up to 60%. So I guess it gets easier with time and experience. So we talked about divorce, and we talked about traditionally how states only permitted divorce for what they called the innocent spouse. But then that changed so that now all the states have this notion of no-fault divorce. And we indicated for no-fault divorce, all that means is a divorce will be granted by a court without either party having to prove fault on the part of the other party. All you have to say is there's been a breakdown of the marriage, and you have to show that there has been some kind of separation. Well, given the number of divorces that we have in the United States, and by the way, divorce generally from my experience is really tough on families. As I said, the attorney who had his office right next to mine was a family lawyer, and he dealt with a ton of divorces. And one thing I learned about divorce is people always talk about it was an amicable divorce. Well, you know what? No offense, I have never seen an amicable divorce. So all the times that I had to witness things or I had helped this individual with some of the paperwork, never saw an amicable divorce. And some of them started off amicable, but then as you go through this process of divorce, you have to do a number of things. You have to divide property. You have to determine alimony. You have to satisfy the creditors of the family. You have to deal with notions of child support. So all of a sudden, what starts happening is when we as an attorney say, for example, a particular wife, look, we want all the financial records of your husband so that we know what we're talking about and how to determine property dissolution. And the wife says, oh, my husband always shows me the bank account, and here's all we got. And we always say, are you sure? And they're like, yes. And then we do searches, financial searches, and guess what? We almost always find that there's more property than the spouse knows about. And all of a sudden, the relationship between the spouses goes south. And it usually gets worse after that. So dissolution is an important thing to understand. And what we want to talk about now in regard to divorce and dissolution of marriage is the idea of property rights. So when we talk about property rights, what we're talking about is the legal rights of a spouse to marital property, which are the assets of that family. And property rights can vary depending upon the applicable state law. Now historically, and for those of you who are taking my discrimination course, you'll know this, historically under common law and common law theory, the title to all property owned by a woman was automatically vested in her husband upon marriage. So the husband owned everything. And if there was a divorce, the husband kept everything. So during marriage, a wife owned no property. And it was called this doctrine of coverture that we mentioned in that other class. Well, today things have changed. And today the right of a spouse to property is a more complex legal issue and depends upon understanding some significant legal distinctions. So most states have adopted a form of marital property law that distinguishes between three kinds of property: separate property, marital property, and commingled property, or commingling. So let me explain what we mean by this. Separate, marital, and commingling. Separate property is property owned or acquired before marriage. Property owned or acquired before marriage by a marital partner. Or it can be property that's acquired during marriage by specific gift or inheritance. In other words, you're married, your parents die, and they specifically leave something to you, and it's in your name. Well, at that point, that is considered separate property, as long as it is kept separate. And what I mean by kept separate, so if your parents gave you, I don't know, $100,000, you would have to open your own separate saving or checking account in just your name to keep it as separate property. So separate property, again, is property owned or acquired by a marital partner before marriage or during marriage by gift or inheritance. So that's separate property. Marital property is property acquired or earned during marriage. And in this context, anything that is acquired or earned during marriage belongs to the spouses. The spouses are seen as partners in marital property. Okay. Then we have this idea of commingling. So what's commingling? Well, commingling is when separate property, and you remember how we defined separate property before, and marital property are combined. They're combined. So once they're combined, legally the courts will say it cannot be traced back to its original status. It all becomes marital property. So as I said before, if you have separate property and then you put it in a marital checkbook or savings account, in other words, both spouses are named as co-owners, at that point it is commingled. And once it is commingled, neither spouse can defeat the other's ownership rights in any way. It is marital property, which means you both have to agree. Now, when something is marital property, one spouse cannot give that property away without the consent of the other spouse. So in your book, I think it's on page 613, they have a legal focus problem. And I said, in Bellevue, Washington, George Thompson was enamored with his secretary, Vicki Ellers, and he gave her a Jaguar, a purchase with earnings from his accounting business. When his wife Betty learned of the gift, she insisted that the car be taken from Ellers. Can this be done? Can this be done? Well, it says yes. Under the law, Betty may insist the car be taken. Whenever either spouse gives away community property without consent, the injured spouse can ask the court to set aside the transfer of property and order the property returned. If, however, the automobile was given to the secretary in exchange for services legitimately rendered, then the gift would be in the nature of a bonus or wage and would not be set aside. So clearly, what you can see from this example is that someone can't just give away marital property without the consent of their spouse. Okay. Well, the next thing we want to talk about after divorce is property rights upon divorce. So we've got this marital property, we've got separate property, and we have commingling. Now you're getting a divorce. So the question is, what happens to the property? What is each spouse's property right? Now the answer to that, again, varies depending upon the state. Now, first of all, there's nothing that says, and judges will accept this, the courts will accept this, that a divorcing couple can't reach a voluntary agreement about dividing the property. So if you both have attorneys and you say, all right, one spouse is going to get this, this, and this, the other spouse is going to get, and you both agree to it, and you sign a contract, the courts will enforce that. But if there is not a voluntary agreement, then the court uses state law dealing with the division of property rights upon divorce. And this is where there are distinctions between states. And there's two major approaches to this. You can have either marital property states or community property states. Marital property states or community property states. So let me explain what the distinctions are between these. In a marital property state, courts are expected to divide the property equitably. Equitably. Now, equitably is not the same thing as equally. Doesn't mean 50-50. It means the court can determine the best way to allocate the property. So they generally have to go through 3 steps. They have to identify all of the marital property, which I've just talked about before. Then they have to do a valuation of all the assets. And then they have to do a final distribution to each spouse. Now, in doing this, in a marital property state, the court will take into account things like the length of the marriage, the parties' abilities to support themselves, the valuing of their professional degrees, whether or not there was any fault in the marriage. Was one party taking advantage of the other in some way, or unfaithful to the other in some way? All of these things could be considered. In a community property state, on the other hand, property division is a lot easier. All family property is considered equally owned and therefore is awarded 50% to each spouse regardless of the circumstances. So the idea again is the respective earnings of the husband and wife during marriage are owned equally when received. And the court will allocate the net value of each part of this property, 1/2 interest to each spouse. So this reminds me of a real example. Mike Tyson was the heavyweight champion of the world. And he married a woman named Robin Gibbons. Robin was a very beautiful actress, but she wasn't a very good actress. So they get married, and they're living in New Jersey. And New Jersey, as it turned out, was a marital property state. So Robin says to her husband, Mike, you know what? I think we should move to California. And she tells him this about 6 months before a big heavyweight fight he was going to have, for which he was going to be paid over $100 million, which at that time was the largest purse in the history of boxing. So Mike's not the smartest guy in the world. So he says, okay, baby. So they moved to California. Well, they lived together for another 6 months. He has the fight, earns $100 million, and the next week she files for divorce in California. And guess what? Just happened to be the case in California. It was a community property state. So therefore she said, doesn't matter, we were only married 1.5 years. Doesn't matter I was unfaithful to Mike. Doesn't matter I didn't work. Doesn't matter I didn't contribute much to the household. Doesn't matter we had maids and everything else that did everything and I really did nothing. Doesn't matter we didn't have any children. I'm entitled, at that time his net worth was about $800 million. I am entitled to $400 million. And in a community property state, that's what she would get. That's what she would get. So that's the way it works. Okay. The other issue that has to be resolved, I'll upon termination of marriage or divorce is how do you deal with creditors of the family? So the question is the extent to which creditors of one spouse can reach the family's marital property. And that varies a little bit from state to state too. Now, according to the Uniform Marital Property Act, all marital property can be reached by the creditors of either spouse. So in other words, if one spouse has a lot of bills, they got a hold of the charge card and they just started charging like nuts. Well, the creditors can then attach any marital assets. So what you're saying is, that's the way it works. Now the only caveat is some people try and defeat the rights of a creditor by putting the title of their property in their spouse's name just to avoid claims of the creditors. So in other words, one spouse is a gambler and they want to defeat the attempts of the creditor to get their property or their home, so they put that property and home in the name of their spouse. Well, according to the law, you can't change title to property simply to avoid claims of creditors. Such transfers can be set aside as being fraudulent. Fraudulent. All right. So that's the relationship of creditors to marital property. The other issue that you then have on dissolution is the idea of maintenance or alimony. Maintenance or alimony. So upon termination of a marriage by divorce, maintenance or alimony can be ordered by the court. And what maintenance or alimony is that one spouse is required to provide money or benefits to their former spouse. So the courts will generally determine how much per month and how long the payment should last. Now, like property division, couples can arrive at a mutual agreement of how they're going to deal with alimony and avoid court decisions. But the court must then approve it. And again, as long as it's entered into freely and voluntarily, that's usually not a problem. Now, when we talk about alimony, the one thing that I want to make clear is alimony can be to either spouse. So if it is a heterosexual relationship, an idea of alimony can be given to either the man or the woman, depending upon their need. So the United States Supreme Court has held that gender-based alimony is unconstitutional. Alimony can be required from one spouse to another if the other is in genuine need. So the amount of alimony that is given to a spouse is related to the needs of the spouse receiving it and the ability of the other person to pay it. Now, in awarding alimony, there are a number of factors that states will consider. 1, the financial condition of the spouse seeking it. 2, the financial condition of the spouse trying to pay it. 3, the length of the marriage. So obviously the longer you've been married, generally the more alimony you're entitled to. 4, the age, health, education, and station in life of the parties. So if one party has been at home as a house husband or housewife for the entire 20 years while the other one's worked, then the house husband or wife who doesn't have an ability to provide for themselves will get more money. Their occupations, their needs and opportunities for future income, the contribution of each in acquiring or maintaining marital property. So if someone is a house husband or a housewife, but they kept the home in great condition, they did all the repairs and painting and everything else, that is considered. The needs of the custodial parent to raise a child. All of these things are taken into consideration. The standard of living. So this is the old accustomed to. What have you been accustomed to? So if you've been living in a mansion and you're accustomed to being given $10,000 a month for spending expenses, then as a result you are much more likely to get a larger alimony payment. Now when circumstances change, alimony can be modified. So for example, one of the things that the courts generally find is alimony ends if a spouse or an ex-spouse remarries. So this reminds me of a very specific case that I know very well, in which there was a woman who was married to her husband for 30 years. She raised 2 children. He was out working all the time. She maintained the house. She cooked all the dinners. She did everything. She gave up her career as a nurse for her husband. The husband made millions of dollars, owned a number of pharmacies, including one right here in Alliance. I won't say which one. And then he starts fooling around with his employees, divorces his wife. His wife, who is now 50 years old, for a 21-year-old woman. So she's awarded alimony, a significant amount because he had a lot of money, and she had done everything for the family, and plus she had 2 sons that she was raising. The alimony was for 10 years. Well, during this time, she meets a man that she falls in love with. And I remember her coming to me and saying, it was about 7 years into the alimony, I am not going to get married for 3 years and 20 days. And I said, well, what happens in 3 years and 20 days? She goes, that's when the 10-year alimony period is over, and I'm going to make sure that my ex pays every cent. Okay, so remarriage would have relieved him of alimony. Okay. The last thing we want to talk about in regard to this whole idea of family law is parenthood. Now, parenthood is very important both during a marriage and upon its dissolution, whether it's through divorce or whatever. And in regard to parenthood, what we have to know is that a legitimate child enjoys rights and sometimes duties of support, and they possess rights of inheritance, and typically they are entitled to whatever kinds of rights that dictates from both the father and the mother. Now, what is a legitimate child? Historically, an illegitimate child was a child born of an unmarried mother or born of an adulterous, incestuous, or bigamous relationship. Now, this traditional definition and approach penalizes the child. So today, states have been more inclined to resolve any doubt in favor of legitimacy. And to that extent, most states have adopted what's referred to as the Uniform Parentage Act. And here's what they talk about in terms of legitimacy. That any child born during a marriage or within 300 days after termination of the marriage is considered the legitimate child of both the birth mother and the husband. Parentage Act also says a man is also the presumed father of a child if before the child's birth he and the mother marry, or after the birth of the child he and the child's mother marry and voluntarily assert paternity, or if he is named as the child's father on the child's birth certificate. So all of those things would lead to a presumption of legitimacy. And this is important because if a child is seen as illegitimate, there is no legal duty to support that child unless somehow the court can establish paternity. And nowadays it's a lot easier to establish paternity than it used to be because of genetic testing. But in most states there has been a trend to equalize the rights of legitimate and illegitimate children. And again, the idea has been that you don't want to penalize the child for the indiscretion of their mother or father. The last thing we'll talk about is the changing definition of parenthood. In these modern times, we have the notion of surrogacy, surrogate parents, and surrogate mother contracts. So for example, if you have an infertile wife, and therefore a woman who is artificially inseminated, she becomes the surrogate mother. Now the surrogate mother is actually the biological mother and carries the fetus to term. And what we have in the United States are what we call surrogate contracts. Surrogate contracts. So the woman agrees to carry the fetus to term and then relinquish her parental rights to the biological father and his wife. The infertile wife then, according to the contract, will then adopt the child, and the surrogate mother is compensated. So on page 619, they give you an example of this that really happened. It says in 1985, William Stern and Mary Beth Whitehead entered into a surrogacy contract. It stated that Stern's wife Elizabeth was infertile, that they wanted a child, and that Whitehead was willing to serve as a mother with Stern as the father. The contract provided that Whitehead would become pregnant through artificial insemination, using Stern's sperm, carry the child to term, bear it, deliver it to the Sterns, and thereafter do whatever was necessary to terminate her maternal rights, so that Mrs. Stern thereafter could adopt the child. She agreed to $10,000 for this. On March 22nd, 1986, baby M was born. On March 30th, she was delivered to the Sterns.